Supreme Court did what the Supreme Court needed to do in the eyes of the Constitution.
Liz Ortenberger, the CEO of SafeNest, understands the legal dilemma. In a recent ruling, the Nevada Supreme Court decided the existing misdemeanor domestic violence charge was problematic because of a 4-year-old state law that required anyone convicted of that charge to lose their constitutional right to possess a firearm. For that reason, the state Supreme Court ruled those defendants would have to get a jury trial, which cities like Las Vegas are prohibited from doing in municipal court for misdemeanors. For now, the city attorney's office has instead flipped those cases to a charge of simple battery, but Ortenberger says that drops the ball.
So when batterers are charged with misdemeanor domestic violence, one of the programs is diversion counseling, which gets them to understand behavior, their triggers, and hopefully curb the epidemic from repeating itself.
As a possible solution at Wednesday's City Council meeting, Las Vegas City Attorney Brad Jerbick proposed an ordinance, battery which constitutes domestic violence. It removes the gun possession aspect, which Ortenberger doubts will hold up.
The city, I understand, is up against a real issue here. I mean, we're looking at 5,000 cases. Statutorily, a city cannot hold a jury trial. So they would have to bind all those cases over to the district attorney's office, which would mean a massive amount of revenue loss. So this is a complicated sort of reality.
Nevada Attorney General Aaron Ford agrees, telling News 3 it cannot be denied that this new jury requirement will have very real and practical effects on domestic violence prosecutions. So these options might have to do in the short term, but Ortenberger is adamant that some long-term solutions are needed to protect victims and to also offer counseling and intervention to stop the epidemic of domestic violence. Back to you.
All right, Steve, thank you.